I'm in Wood Lane and I'm speaking. What I'm speaking about this time is yet another attempt at grabbing power by the current administration. But this attempt at grabbing power is one that's based on omissions of truth and basically lies. And what this is about is there is a trending story from this weekend in which the current administration is looking to void federal employee union contracts that were negotiated and agreed by former President Joe Biden during what is known as the transition period. Um, an example, in at least in the news report, is in Huffington Post, where the headline says that the administration plans to nullify federal union contracts. The administration said agreements reached late in Joe Biden's president were meant to harm my administration. The article goes on to say that the harm to administration is in part by undermining its return to office mandate, and that he intended to scrap them and bargain his own contract negotiation. So the article goes on to make reference to that, specifically a contract that was ratified with the Education Department back on January 17th, which is 3 days before the Orange Felon Liar took oath of office for this second administration. The article goes on to quote the Orange Felon Liar as saying such last minute lame duck on collective bargaining agreements, which purport to bind a new president to his predecessor's policies, run counter to America's system of democratic self government. Now, for whatever it's worth, the term self government is found twice in the Project 25 document that this current administration is using as a blueprint to accomplish certain legislative and administrative agendas. The article goes on to say that the memo did not make clear its legal justification for nullifying existing union contracts. But the administration referred to a 2010 Supreme Court decision that stated a president cannot choose to bind his successors by diminishing their powers. Now, um, speaking as a former newspaper reporter, um, I'm going to say this about the article. The article almost to me sounds as if it just regurgitated a press release and maybe asked at best one question or two. Other source that I used um, from the government executive website, the headline says that Trump signs the administration signs memo that claims to cancel late Biden era uniform that the administration signs memo that claims to cancel late Biden era union contracts. The headline also says, although the president railed against collective bargaining agreements signed at the Social Security Administration and the Education Department shortly before his inauguration, it's unlikely any of those details will be upended by the measure. So the issue is that in the second paragraph of this particular article, it says the administration, Elon Musk, and congressional Republicans in recent months have railed against then Social Security Commissioner Martin O'Malley for signing a contract last November with the American Federation of Government Employees, locking in existing telework policies until 2029. And the Education Department similarly entered into a new contract with the AFGE effective January 17th. So the American Federation of Government Employees National President Everett Kelly said at the end of this article says that he dismissed the memo by the administration as an effort to frighten and confuse federal workers. Federal employees, he said, should know that approved union contracts are enforceable by law, and the president does not have the authority to make unilateral changes to those agreements. AFGE members will not be intimidated, he says. If our contracts are voided, if our contracts are violated, we will aggressively defend them. Okay. Now, You have to look farther into what's being said to really understand the full scope of this power grab, this attempted power grab by the administration. The reference to a president can't choose to bind his or her successors, and I'm saying that because in the actual piece that I will show you, it says his successors by diminishing their powers is from a case heard by the U.S. Supreme Court in 2009 and decided on June 28, 2010. This case was the Free Enterprise Fund versus Public Company Accounting Oversight Board. Now, the decision was narrow in that it was a 5-4 ruling in which Chief Justice John Roberts wrote the majority opinion. It was dissented by Justices Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and John Paul Stevens. Now, that should be a clue. A couple of names that also should be mentioned in associated with this case are current Justice Elena Kagan, who argued on behalf of the U.S. government, serving as the U.S. Solicitor General. She is the person who replaced John Paul Stevens upon his retirement back in 2010. Another name that was referenced in a court opinion was that of Brett Kavanaugh, who previously served as a justice on the U.S. District Court of Appeals for the District of Columbia, that is Washington, D.C. Now, according to the source that I actually kind of gained an understanding about this particular case, and you'll see in relation to this article, is from OIE. That is a site that archives U.S. Supreme Court cases. And according to OIE, they say that this case alleged that the creation of Public Company Oversight Board violated the Appointments Clause because it deprived the president from exercising adequate control over the board. However, the board itself was under the direct supervision of the Securities Exchange Commission, the SEC, all of whose commissioners are appointed by and can be removed by the president. The U.S. Court of Appeals for Washington, D.C. held that the creation of the Public Company Accounting Oversight Board did not violate either the Appointments Clause or the separation of powers principle. It reasoned, though, that the board's members were inferior officers under the supervision of the SEC and thus were not obligated to be appointed by the president. Also, the court noted that the president's ability to remove members of the SEC, who in turn could remove members of the board, preserved the Constitution's separation of powers. So, let me go ahead on and point out some other things then. This case was based on questioning the constitutionality of Title I of the Sarbanes-Oxley Act. And what is then the Sarbanes-Oxley Act? It was passed by Congress in 2002, establishing a Public Accountability Oversight Board as a nonprofit organization and thereby, in principle, being nonpartisan, and whose intent was to protect the public from corporate accounting fraud and corruption. Remember the Enron case. In fact, that's the basis of this. By making transparent publicly traded companies' financial information through audits and various public filings. In other words, the goal was to restore public confidence that publicly traded companies were in fact not cooking their books. And it also made accounting firms accountable. Now, these members of this accountability and oversight board were not considered government officers. They were, in fact, people recruited from the private sector and paid salaries above the government's pay rate. Remember the term, it's not my pay grade, it's above my pay grade. So then, the argument wasn't about the accountability part of this legislation. It was all about controlling whom these members of the accountability board would make themselves accountable to. These people, according to the majority opinion's reasoning, were appointed to 5-year terms by the Securities Exchange Commission, whose leadership is appointed by the president. Thus, it is a government-created entity charged with enforcing the Sarbanes-Oxley Act. It is then under the SEC's oversight. But here's the reason why this case came about. An accounting firm, Beckstead and Watts, which were members of the Free Enterprise Fund, received an unfavorable audit of their auditing procedures that was subject to penalties and fines imposed by the Public Accounting Oversight Board. So the bottom line is that they didn't like it, so they sued. They argued that this Public Oversight and Accountability Board should be subject to the President of the United States. So then the board members, the composition of the board members, they argued was unconstitutional because they were not subject to the President of the United States oversight. So using then a technicality, this sounds like indirectly like back in 2024 when Special Counsel Jack Smith, who was investigating the Orange Felon Liar, his role as special counsel was deemed by a federal district court judge as not constitutional. His role, as reasoned by this judge, was not created by Congress, nor did Congress specify to the U.S. Attorney General that this special counsel role needed to be created. So then the question is, how does this undermine an incoming president's powers? How does this have anything to do with Joe Biden's administration having negotiated a labor agreement with the federal employee union? Now you got to go back into the case. According to the text, according to the majority opinion text, that is, the court agreed that the executive power, the President of the United States, according to the Constitution, has agreed by oath to faithfully execute the laws of this country. But one person, the court reasoned, should not perform all the business of the country. The Constitution allows for executive officers to assist in the administration of the country. The president is empowered to keep those executive officers accountable by removing them from office, as John Roberts wrote, but that power is limited. Okay? Congress can create independent agencies that are run by principal officers appointed by the president. The court reasoned that the president, based on the board setup, had no power to hold members of the board accountable for their actions. The board, in effect, was insulated from a president also meddling into their business. The board was then set up to be independent of the president, that is the executive branch, and that being seen as a separation of power. But there was a legal argument to suggest that the board members could be removed if their behavior is egregious. So this, and as I kept reading, I discovered the line that this administration is using as its basis of argument, and which I will say up front is not tangible to the federal employees collective bargaining agreement. Now, what I'm about to read now is from the actual text of the majority ruling, again, that was written by John Roberts. And I have to go up a couple of paragraphs so that you can get the full context of what's going on here. It goes on to say, if allowed to stand, this disbursement, spreading out of responsibility could be multiplied. If Congress can shelter the bureaucracy behind 2 layers of good cause tenure, why not a third? At oral argument, the government was unwilling to concede that even 5 layers between the president and the board would be too many. The officers of such an agency, safely encased within the Matryoshka doll of tenured protections, would be immune from presidential oversight, even as they exercise power in the people's name. Perhaps an individual president might find advantages in tying his own hands, but the separation of powers does not depend on the views of individual presidents, nor on whether the encroached upon branch approves the encroachment. The president can always choose to restrain himself in dealings with subordinates. He cannot, however, choose to bind his successors by diminishing their powers nor can he escape responsibility for his choices by pretending that they are not his own. The diffusion of power carries with it a diffusion of responsibility. The people do not vote for officers of the United States. They instead look to the president to guide the assistants or deputies subject to his superintendence. Now, without a clear and effective chain of command, the public cannot determine on whom the blame of punishment of a pernicious measure or series of pernicious measures ought really to fall. So this is about accountability, and this is about accountability. This is not about negotiating of a contract and whether the timing of the contract negotiated actually diminishes a president's power. It has nothing to do with it. This is about people not agreeing with the people who made the decision, and so they're trying to find a way to some type of legal way to basically nullify the decisions that were made. So if I would go on to if I were to go and explain further, so is a president's power diminished because a legally binding contract is enforced that the succeeding president doesn't agree with? This is nothing more than taking one part of a passage and making a bigger argument. It was out of context. It's not really a valid argument, and it's also without precedent. But I can see where they will then try to push for a case that will define exactly what this means, twisting and contorting something that will help them to achieve their agenda. So, by its declaration, the current administration is saying that the contracts are legal. These are actually legal and binding contracts, and that the president must faithfully execute the laws of this country. The president is then not faithfully executing the laws of the country, but is, as the term used by the Supreme Court in this ruling, contravening, meaning flouting, ignoring, diverting, breaching, or disregarding it. So this administration is trying to breach and disregard, as it has with so many other things. Now, there's the Chevron ruling that has been in the news in 2024, in which ruling that depended on technical competence for certain decisions and rulings be made by government agencies. The Supreme Court said, well, not exactly, not so. So the argument then is something that's set up for public good may be so in name, but not in practice and application of it. It may be subject to challenge, or at the very worst, likely minutely defined roles and responsibilities and administration of it. So, as I kind of wrap things up, I hope I've made a good effort at unwinding something that's been convoluted, because that's what this administration, that's what the Orange Felon Liar has been good at, convoluting and distorting information, spreading lies and misinformation, and this is yet another example. So the other thing about this is that with so much that's coming out, I mean, you really don't have time to really dig into everything. I mean, you almost have to pick one thing, but realizing that you're being bombarded with so many other things by this administration, and that's all by design. It's all by design. But hopefully, you see that the argument made is being taken out of context. This is based on a completely different case. It has nothing to do with a president diminishing another president's power. Joe Biden did not diminish Donald Trump's power by negotiating a contract when he was still in power, where he was lawfully in power, legally in power to do so. He was still the president of the United States. So therefore, he could do that. That's the bottom line. So because the Orange Felon Liar does not like it, and that he has the Department of Education in his crosshairs anyway, he's trying to make an argument, and hopefully, basically throwing shit against the wall, and hopefully that it will stick. And the unfortunate thing about it is that there is a possibility it may stick, because you may think of it this way: if a case is brought before the Supreme Court, well, John Roberts is the person who wrote that line, number one. So then it's going to be a question of John Roberts. Do you believe what you wrote is true? The other thing is that Brett Kavanaugh had already argued on pretty much established had put forth an opinion that the court referred to, in which he's basically he's basically small government as well. And then Elena Kagan, she was Solicitor General, and there's an argument that she may need to recluse herself from this particular case because she argued the case. So then that leaves you really Amy Comey Barrett, who I really wouldn't call her a swing vote by any stretch of the imagination. So that's thinking ahead. That's probably more like along the lines of Ellie Mistio, who can tell you, who probably give you a better handicapping of the probability of what may come out of this. But just know that this administration is pulling all stops, making all kinds of rationalizations, whether founded or not, to try to accomplish what it's set out to do. So with that, hopefully you got something out of it. Look for the next upload, and I am Inwood Lane, and I'm speaking.